All right, all jurors are accounted for. We can be seated. Mr. Bowie, you're a foreperson. Yeah. Bowie, you have a verdict. So I'm going to review it just to make sure everything's been checked off appropriately. After, if it's all in order, the clerk will ask you each one if this is your verdict, and then we'll take it from there, okay? Okay, all right, Ms. Link. The state of Florida versus Daisy Link, case number F2211523. Verdict, we the jury in Miami-Dade County, Florida, find the defendant, Daisy Link, as to count 1, second-degree murder, guilty of second-degree murder. If you find the defendant guilty of second-degree murder, you must answer each of the following questions. Number 1, did the defendant actually possess a firearm during the commission of the crime? Yes. Number 2, did the defendant discharge a firearm during the commission of the crime? Yes. 3, did the defendant discharge a firearm causing death during the commission of the crime? Yes. So say we all, the 16th day of October 2025, signed by the foreperson. All right, Marilise, we're going to poll the jury.
Jury, if you have rejected the verdict, as I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Keenan Bowden?
Yes.
Ramona Espinosa?
So there they go. They about to poll the jury. Y'all know when she requested a new trial, we did go over that paperwork here, right here at Take It to Trial. We covered that. Let me find out what date that was for us so we can know what we working with. And if anybody needs to follow up on this trial or didn't see the trial, there is a Florida versus Daisy Link playlist for anybody that is interested. And Daisy Link is accused of, she got convicted of redrumming her boyfriend, also her child's father, which was a long-term relationship, and she was pleading self-defense and a stand your ground rule. The new trial for motion was actually, we reviewed it over on about a month ago. Oh, let me see. So the date that she filed for a new trial, guys, just so y'all know, was November the 21st, 2025. And as of yesterday at about 3 o'clock, a new trial was granted. I don't even understand how this works. Like, Florida must really have a good way of moving things through certain systems, because for most new trials, like, they doing all this testimony, they doing all this extra stuff, and it's taking forever for these trials to kind of like come forward. But not for her. Her new trial was granted yesterday and filed. So we talk about what? December, January, 2.5 months? Dang, that's quick. Y'all don't think that's quick? When you're thinking about people like Zach Adams, with the Holly Bobo trial, like how long that's taken, and Richard Allen, like those seem more egregious, to me, but apparently not. So let us get into this document. Okay, I want to hide the thumbnails. Okay. So here we go. This was filed February the 5th, 2026, which was yesterday at 1:33 p.m. Order granting defendant's motion for a new trial. This matter came before the court on the defendant's motion for a judgment of acquittal, notwithstanding jury verdict, and in the alternative motion to set aside verdict and a new trial was filed on October the 23rd, 2025. Okay, so I guess they originally filed it on October the 23rd, 2025. And the court, having reviewed the motion, defendant's supplemental memorandum in support of the motion for a new trial and or motion for a judgment of acquittal, notwithstanding jury verdict, filed November the 21st, 2025. And the state's response to the defendant's motion for a new trial and supplemental briefing filed December the 10th, 2025. They heard the argument of counsel, reviewed the record, and otherwise being abides in its premise, hereby finds as follows. Let's get into it. I like these things. If y'all don't have one of those, I'm gonna try not to smack all the way through this. Be sitting up here smacking. Hey, Carvel, how are you? Okay, let's get into it. Okay, the defendant, Daisy Link, was charged by the information with one count of second-degree redrum with a firearm in violation of section 782.04 and 775.087 in Florida state. A life felony subject to a firearm minimum mandatory sentencing. Defendant contended that she acted in self-defense and or in defense of others, claiming in part that the decedent, the baby daddy, the father of her two children, was attempting to commit burglary of her home. Defendant also contended and presented evidence that she had been a victim of domestic violence. Remember, we saw that she got her ass whooped. Y'all remember those photos that we seen? She got beat down a couple days before. And she presented that evidence. The case proceeded to trial the week of October 6, 2025, and the jury returned its verdict on October the 16th, 2025. Remember, in 97 minutes, we just saw the verdict. That verdict was rendered. The state called numerous witnesses and introduced a key piece of evidence in the form of a post-Miranda statement by the defendant in which she explained her past relationship with her baby daddy, the events leading up to the shooting and the shooting itself. The defendant explained in the statement that she had been beaten over the head by the decedent, like beat up. Y'all remember that big gash that we seen in her head? Oh my goodness, it was terrible. A few days prior to the shooting, had thereafter armed herself with a firearm, and at the time of the incident, not wanting to be locked out of her home, she shot at him to stop him from entering the home. At the trial, the defendant called only 4 witnesses, including her mother, who testified that the decedent had been known to gain access to the defendant's home by reaching his arm through the back window, allowing him to open the door from the outside. The mother also testified that she had seen photographs of the gash of the defendant's head from the battery that had occurred at the hands of the decedent. The mother had traveled from Texas all the way down to Florida to help her daughter move. Additionally, her mom also observed an argument between Daisy and the decedent the day of the shooting. The mother corroborated the injury to the defendant's head. The mother also corroborated that the decedent did not have a key to the home. The defendant testified and presented evidence that the decedent was not allowed unsupervised visitation with their 2 minor children. The defendant also testified while the decedent had been allowed to come into her home, from time to time and even sleep over on occasion. She had changed the locks and he did not even have a key to her home. So that on the day of the shooting, he was essentially an unwanted visitor. Okay. She didn't want him there. So during closing arguments, the state showed a PowerPoint presentation to the jury, which included part of it in its closing arguments. Okay. The jury instructions and the photographs of defendant's home that it purportedly intended to introduce as evidence during the trial. It was later discovered after the 4 photographs, Exhibit A. Remember, if anybody remember, the jurors had a question. It was about one of the photographs. I remember they got that photograph and they came back 5 minutes later with a guilty verdict. I bet you this is the pictures. This is part of these pictures. I bet you. So they discovered after 4 photographs, Exhibit A, were shown to the jury that the photographs, in fact, were never presented at the trial nor introduced into evidence. Oh my. So they were showing photographs that were never introduced into evidence. The state not only showed the jury, but then utilized those 4 paragraphs to discredit the defendant's mother's testimony by arguing that there was no evidence of any broken windows or damage to the outside of the defendant's home. The state further argued that the decedent had never broken into the defendant's home, and therefore the mother's testimony was not to be believed. Okay, let's see what Exhibit A. Let's see if they put some photos in here. Exhibit A. So these is the photos that they're talking about that were entered into evidence. What's this ladder about? Is that to her house? I'm sure we're gonna find out about Exhibit B soon. Okay, we won't go to Exhibit B till we get to that one because I have no clue what that's about. Okay, so that's Exhibit A. Okay, here we go. Soon after the jury began deliberations, they sent a note marked as Exhibit 7 and attached here as Exhibit B. There we go. Okay, this is the note. Remember, I told y'all, I knew this was what it was. Oh, I knew this what it was because this was a problem. I remember them having a whole issue with the way they were going to present this when we were watching the trial. Okay, so this is Exhibit B. This is the note from the jury. Damn, I need to flip this. This is so upside down. I can't read this. I don't know how to read this. Damn. Oh, wait a minute. I wonder, I don't know how to rotate anything in here. Yeah, so if y'all need me to rotate, let me see. Oh, let me see view. No, I don't know how to rotate nothing. The only item I don't know. I can't read that. Good luck. You know, I'll see if I can put the link or whatever into Discord if you want to look at it. But shit, I don't know. I can't see that, and I don't see nothing to kind of like turn it around, y'all. I'm sorry. Y'all know this is my first. You know, I don't never look at this stuff before I look at y'all. Before I get to talking to y'all, I better start looking at stuff. I always say I'm gonna go look at the stuff and I never look at it, but whatever. Okay, I don't have time to look at nothing. Okay, so that was Exhibit B. After the court conferred with counsel for the parties, it was agreed that the request from the jury for the evidence of the back door close proximity to the window was for the four photographs the state showed to the jury in a PowerPoint and argued in its closing. The state conceded to its improper conduct and apologized for the mistake. After again conferring with the parties, the court allowed the 4 photographs to be introduced as trial exhibits marked as State's Composite Exhibit 32, and they allowed the defendant to introduce a photograph marked as State's Exhibit 34, attached here to as Exhibit C. We'll go down and look at that in a minute. Showing damage from the inside of her home as a counter to the state's photographs. The 5 additional photographs were shown to the jury. The court then allowed the defendant to make a 1-minute argument as a continuation of its closing in effort to cure the error created by the state's improper closing argument. Wow. Okay, number 2, the motion for the new trial. Defendant filed a motion for a new trial setting forth numerous grounds, one of which the court addresses below. Florida Rule of Criminal Procedure 3.600B8 requires a court to grant a new trial if substantial rights of the defendant were prejudged. I don't know what that word is. I don't get me wrong. I don't know. I ain't gonna even keep trying it. I want to say prejudicial, but it's not prejudged. That word, prejudged. Y'all see it. Y'all go for it. As a result of any cause not due to the defendant's own fault, and the defendant did not receive a fair and impartial trial. Okay, and so then they quote some law, right? Here we go. Okay, abuse of discretion of denying a motion for a new trial where the state introduced collateral or crime evidence in the violation of the motion in limine. Okay, then we got some more quotes of some law. Once the trial court properly determines prejudicial information was erroneously omitted during the trial, and where it cannot grant a motion for judgment of acquittal nor arrest the judgment, it must grant a new trial. So they saying, hey, we can't give you a judgment of acquittal, but I mean, we can grant you a new trial. That's about the best that we can do. The court must grant a new trial where for any cause not due to the defendant's own fault, he did not receive, he or she, I'm gonna say he or she because it's a she, he or she did not receive a fair and impartial trial, providing the substantial rights of the defendant were prejudged. I'm gonna figure out this word. I'm gonna look it up. I'm gonna have somebody say it to me. I'm gonna have Google say it to me because I see it's gonna be in some stuff here. Okay, here we go. Defendant's substantial rights were prejudged. I don't prejudge this. Prejudge this. Let me see. Let me stop and see what it say. Y'all know I'm crazy. Yeah, this is why I couldn't become an attorney. I don't know. On a good day, I probably can't say. Okay, here it goes. Oh, okay. So, look, I'm getting a definition too. You know, like I'm gonna get it all now. Let me see what it say.
Prejudiced.
Oh, prejudice. Like, why couldn't I figure that out? Good grief! Like, And I'm seeing all the other words, prejudice. Like, oh goodness, good grief. I am going crazy today. Prejudice. Like all this time, I couldn't figure out how to say the dang on word. I tell you, when I think too hard about saying something, I can't never say it. It ain't gonna happen. I'm like, I gotta see what this word means because I keep running into it. Okay, prejudice. Like, why did I not figure that out? Whatever. Okay. By cumulative effect of the errors listed below, and as a result, did not receive a fair and impartial trial. The errors deprived the defendant of a fair and impartial trial and likely materially contributed to the jury's finding of guilt, right? So the efforts to address the state's improper closing were ineffective in alleviating the damage that had been done. So accordingly, the defendant is entitled to a new trial. So it was just a technical error in regards to these photos that they had said about, they talked about in their closing statement. The jurors was like, okay, well, what are these photos? Can we see them? They sent them back to the jury room, even though they tried to allow, and I remember this part in the trial, and it's stuck out like a sore thumb. So the following errors have cumulative effect on depriving the defendant of a fair and impartial trial. The publication of photographs not in evidence, Exhibit A, the 4 photographs during the state's closing argument. A state's closing arguments seeking to discredit the defendant's mother based upon the 4 photographs. The state's closing argument using the 4 photographs and seeking to discredit the defendant's mother. Testimony to contradict the defendant's claim of self-defense or defense of others. And the court allowing the jury to see the additional evidence once they had retired, contrary to Florida's rule of criminal procedure. Okay. The 4 photographs presented during the closing argument. So it appears that they are allowing her to have a new trial solely based off of this information that was with these photographs and how they were argued. Okay, so after hearing argument from both parties, reading their respective files and reviewing the record in light of the court's observations at the trial, it is clear that the 4 photographs and the closing argument related to them, which came in at a critical time in the trial during the closing argument, which was almost impossible to rebut, but significantly prejudiced the defendant and deny her a fair and impartial trial. The attempted curative steps taken by the court resulted in further errors, and were not permissible, as discussed in Rule 3.430 and the applicable case law. Do not allow a jury to be recalled to hear additional evidence once they have started deliberating. So they can't look at new evidence once they start deliberating. During the trial, the defendant elicited and introduced evidence that she was physically smaller than the decedent, had herself been a victim of domestic violence at his hands. The decedent was not allowed unsupervised visitation with her 2 minor children. She had changed the locks to her home. The decedent was not allowed to enter her home on the day of the shooting. And her mother had traveled to South Florida from Texas to help her and the children move out of town. Wow. So of significance was her post-Miranda statement that while she allowed the decedent to keep a gun in her home, she had armed herself the night of the shooting so that the decedent would not hit her, thus equalizing her to him. Okay. I don't remember if we listened to her. I'm pretty sure she had her interview, and I'm pretty sure, I just don't remember anything like really standing out to me about it, but I'm pretty sure there was. The post-Miranda statement and her trial testimony was that she shot only to scare him and did not intend to kill him and wanted to stop him from entering her home and locking her out. I can see that. Remember, he got shot in the foot and he appeared to be running away, right? So if he was turning around to run away to go to the house, to go in the house and lock her out, that would make sense. It's just he had bad luck where that bullet traveled, right? Mm. She also testified that her children were asleep in the house, and as mentioned previously, the decedent was not allowed unsupervised visitation with the children. Evidence of a motive for the defendant to cause the decedent great bodily harm in this case was not overwhelming. In her post Miranda statement, she told law enforcement that she did not want to be locked out of her home and did not think she had struck the decedent. The decedent's actions after the shooting were caught in part on a Ring camera. Remember, we seen him kind of running away. It depicted her in a calm manner, walking past the front of her home. While the state argued this attitude depicted a lack of fear, the argument could also logically be construed as also lacking an intent to harm. So she was like, "You'll be fine, homie. I ain't even hit you." At least she didn't think she hit him. The defendant was also observed on a Homestead police body-worn camera, crying, screaming, and tending to the wound of the decedent, also evidence of lack of intent to harm him. And on a body-worn camera, the defendant is heard calling the decedent her husband, with whom she shares 2 children with. The defendant argued self-defense, and the jury was instructed accordingly. The jury was given instructions 3.6F with a modified justifiable use of deadly force, which included self-defense and defense of others. Within a few minutes of beginning the deliberations, the jury presented a question, Exhibit B. Counsels for the parties agreed. The jury wanted to see the 4 photographs and the state used in the PowerPoint presentation. While the state's contemporaneous apology and admission of error in using the photographs not admitted into evidence is commendable, the damage had already been done, y'all. Not only what was unadmitted evidence presented to the jury, but it was also coupled with argument used directly to discredit the defendant's self-defense claims and as a key witness in the case and the defendant's mother. So the state's closing arguments began on page 45 of the October 16, 2025 transcript. On page 47, the state describes the relationship between the decedent and the defendant as toxic. On pages 68 and 69, the state addresses the defendant's mother and her testimony. The state seeks to discredit her on page 69, lines 5 through 10, specifically that the mother did not come from Texas to remove the defendant from a dangerous situation, nor did the mother witness the decedent choking, nearly murdering, or unaliving her daughter. That's on page 68, lines 24 through 25. On page 72, lines 14 through 25, the state called both the defendant and her mother liars based on the 4 unadmitted photographs. Daisy told us Daisy told us an interesting lie yesterday, and her mother did too. That was completely refuted by the actual evidence. They said that Pedro punched through the wall and opened this door. Well, good thing we have photographs. Tell me where there's a broken window. Even if he punched through that, look, I am not the biggest guy in the world, and I don't believe in superheroes. I don't think Pedro is Mr. Elastic. He cannot open that door from there. Oh, he bringing in the Incredibles? Ooh. Okay, I love the Incredibles. How dare you? No. There is no broken window here. There is no broken window. There is no punch window. That didn't happen either. Lie after lie after lie after lie. Okay. The state continued on page 75, line 25. The state addresses the jury instructions on justifiable use of deadly force. They go on to address this instruction on page 76, lines 3 through 8, and bring a burglary to a dwelling. Okay. As one of the crimes in the instruction, and go to argue on lines 9 and 10. I am not going to talk about those because there's evidence of those. This is followed discrediting the mother's testimony about the prior damage to the defendant's home on pages 68 through 73. So then they go into the mother's testimony. The mother previously testified she came to South Florida to help the defendant move. The decedent did not have a key to the home and had broken into the home in the past by reaching through the back door window to unlock the adjacent door. By showing the photographs from the outside of the home, which included the windows and the back door, and arguing there was no damage as confirmed by the photographs. The state sought to discredit this important witness by discrediting her. Remember, she was the same one that was out in the hallway watching court TV, and they came and had another attorney that was working for somebody else come in there and snitch on her. And she was like, I did not know I could not be watching the court trial hearing outside of here. And no, I wasn't watching it. But then she got caught on the stand with, yes, she was watching it. Oh, goodness. I remember her. The state's argument affected the self-defense claim since this court has instructed the jury on a self-defense claim with burglary as a crime the defendant was defending. The court has a reasonable doubt that this evidence did not have an impact on the jury's verdict. The court has serious concerns about the other effects resulting from the state's use of unintroduced photographs coupled with their arguments. So I wonder, is it because it's such a erroneous and egregious error, right? Because you can't, how you don't send stuff back or present stuff to the jury that wasn't entered into evidence? Maybe that's why they did this so fast. So then they cite some cases in regards to how the jury can receive evidence. Okay, so this cumulative effect of errors contributed to the jury receiving information that they were not allowed to receive. I guess it would be no different than them up there looking on Facebook, looking on different things while they are in the trial. And this information, it went directly to the defendant's self-defense claim, and the court has reasonable doubt as to the verdict based on the errors. For that reasons detailed in this order, a motion for a new trial is granted. Boom. So we got the photos. This window definitely looked like it's been broken out. It looked like it got paper and stuff up here. And I guess they say he ain't Mr. Elastic. He can't come through this window and go that way. I don't know. I don't know how long his reach is, but I don't know. Y'all think, I guess this window look like it's all the way broken out to me. But who knows? Yeah, so there we go, guys. So that's our motion for our new trial. I think she deserves a new trial on that. Now, I don't know if she's gonna get a different outcome. Maybe her and the family will have everything together. Because remember, when they got up on the stand, remember, it was her sister, her son, her mom, and then herself. So them 4 people testified. You know, this is the case where we had the doctor that he got on the stand, and he was like, yeah, he had a healthy dose of that Coca-Cola in him. What is a healthy dose of a drug? I didn't even know they had healthy doses until he came up there and testified, talk about, yeah, homie had a healthy dose of that Coca-Cola up in his system. I guess just enough to keep him alive to run around the corner. Yeah, so that is that. Let me see. I was trying to see if I seen any of the clips that where we had that information. Um, and it wasn't like she shot at him multiple times, y'all. She only shot once. I mean, the luck of that coming in the back of his foot and traveling up to a major artery in his thigh is like, dang. That's all I could say for that one. Like, damn. Like, that gotta be the worst. Yeah, I was trying to see if I could pinpoint exactly those moments in court, because I definitely remember them coming in and asking for I definitely remember them asking for that photo, and I remember that being a whole hoopla. And just so y'all know, like I kid you not, if I'm remembering this the way I think I'm remembering it, right after they got that photo, they came out 5 minutes later and found her guilty. So that photo was very important. 4 photos, now mind you, 4 photos that were not ever admitted. Let me see. Yeah, remember they were fighting over even the mom's testimony. They were trying to get it tossed. Yeah, I don't know what I did with it. I have to find it. I have to find it. I don't know. I don't know what I did with it. So I guess we'll have a new trial coming up. Yeah, I don't think he getting out of prison. I don't think he getting out. That's why they was up there making that baby. They ain't had nothing but time to make a baby. To make a baby. To make a baby. Okay, well, that's all that I have in regards to the reading. I just wanted y'all to see what that was about. I am going to go ahead and premiere that the opening statements for our for our false trial. It will be the first day's testimony, and it'll also include the first 2 witnesses who were firefighters. Don't forget, we're going to mark our calendars for next Friday. We have sentencing for Twerking Tina, BB's all pair. We have that coming up next Friday, and then we'll be in this case next week that we were doing with the false trial. Yeah, and what else we got coming up? So I'll do the premieres for everybody so we can kind of make sure everybody is up to date and caught up for Monday, because you know we're gonna have fireworks in the courtroom. We'll have those fireworks, and I want y'all to be ready. So just look out for the premiere. Like I said, the first day of testimony, we only have maybe like about 3 hours or so. So I'm gonna actually go ahead and premiere that like in an hour or 2. So I'll say about an hour. I'll go ahead and premiere that so y'all can go ahead and watch that. whoever didn't see it and whoever needs to get caught up. So if you're on a replay team, definitely look out for those premieres. I'm gonna do days 1 through 5 over the weekend so everybody can catch up, because I think this case was kind of, and not talking about the Daisy case, but I think that false case was like dropped in our lap. Like, we were literally watching another trial that morning, Monday. What were we watching? We were waiting for BB's guilty verdict to come back. So we're waiting on BB's guilty verdict to come back, and it came back, and next thing I know that it was a whole nother trial. And we was just like, okay, well, let's go over here and just look at opening statements to see if we want to do anything with this. And we got in opening statements and we were like, dang. We was like, oh, we got to watch this now. We need to understand what's going on. And I'll see if I can get this put in there. I don't know how to flip this note. I was trying to flip it so I can see it, but I don't know how to flip it. I am not tech savvy, and I'm not about to try. And I will see if I can put it in Discord. I think I'm going to make a thing in our Discord just for documents, just so y'all can have them. Any of these documents, in case anybody wants to go along, find them. I'm going to make us another one, text channel documents. So that way y'all can go up under. We got graphic photos. We got ideas and feedbacks. We have events. We have our general where we just kick it. And then I don't know what that is. Let's take it to trial advice. I don't know what that is. Let me hang that up. I don't know what that is. And I guess we got a thing where we can like talk. I don't know. I'm still working on this Discord thing. If you haven't joined our Discord, go ahead and join that. It's kind of where we hang out when we're not online. But other than that, if you not watching any of the premieres, I will do a live. Maybe I'll do it tomorrow. I don't know. I think I may do it tomorrow, or maybe we can do it tonight. I don't know. I'm gonna do a live over the weekend, and the live will be in regards to another case that we got. So okay. All right, guys. Well, I want to thank you. I'm playing our outro song, and I will see you on these YouTube streets. If not, I will see you in here when we go live at some point in time during the weekend.